Matter the people of the state of Michigan versus Kevin Lewis Bell, file number 24-01729, council appearance.
Good morning, Your Honor. Case Mark Darian appearing on behalf of the people. First, a motion to practice under Michigan Court Rule number 8.120.
May it please the court, David B. Carter Jr. on behalf of Mr. Bell, who is present.
Okay, how are you, Mr. Bell?
Well, how you doing?
I'm doing well, thank you. Today's the date that was set for a preliminary examination for a weapons carrying. My understanding is it's going to be a waiver, is that correct?
That is correct, Your Honor. I've had the opportunity to discuss with my client what a preliminary exam is. That it's basically a process hearing to determine the cause that crime was committed and that he committed that crime. It's our desire, my client's desire to unconditionally waive his preliminary exam and proceed to circuit court where negotiations will continue.
Yes, Your Honor. The people would also unconditionally waive our right to a preliminary exam. It is my understanding and hope that negotiations will continue.
Okay, let's see here. Okay, Mr. Bell, you understand the purpose of the preliminary examination?
Yes, Your Honor.
So you have the right to require the prosecution put forth evidence here in the district court that would establish they have sufficient probable cause that a crime was committed and then probable cause sufficient to charge you with the crime. You understand that?
Yes, Your Honor.
And you wish to unconditionally waive your examination?
Yes, Your Honor.
Is anybody threatening you to do that?
No, Your Honor.
Should any promises extended to you entice you to waive your exam?
No, Your Honor.
Your binder of date's going to be September 11th. That date, the circuit court is going to get the file from the district court. You do not need to appear in circuit court on that date, okay?
Okay.
The next court date will be a pre-trial. Your attorney will be made aware of that, okay?
Yes, Your Honor.
Still on Hag Road?
Yes.
Okay. Bond was set at 2,000 personal work harnesses, and that will continue as well as all bond conditions. Any additional matters for the record?
Nothing further from the people. Thank you.
Nothing further for the defense.
You're all set. Thank you.
Thank you.
Are we running Knox?
No, Your Honor, that should be a plea. I have a plea sheet here.
Okay, Knox, can we brought up? Running Macaulay.
I believe we are, Your Honor, yes.
That's correct, Your Honor, we are.
Okay, sounds good. On the record in the matter of the people of the state of Michigan versus Kennedy Atkinson, file number 24-02062. Council appearance, please.
Morning, Your Honor. Case Mark Karen appearing on behalf of the people.
Good morning, Your Honor. Toby White on behalf of Mr. Atkins, and Mr. Atkins and I are appearing by Zoom. And if my camera's not working, I'm going to punch in with my phone. If the court would give me one moment.
Yep, your camera is not working.
All right. Okay. I should be appearing now.
Yep, I can see you now. Thank you. Let's see. Okay, this was a hearing set for an amendment of bond. I received a stipulation to change a number of bond conditions. I don't change bond conditions under stipulation, especially the conditions here. I put them on under house arrest. I think its original bond was set at 100,000 cash surety. I amended it to a PR bond with GPS tether and house arrest. And I got a stipulation for him to be able to leave the house Monday through Thursday, 5 p.m. to 9 p.m. and the hours of noon to 4 on Sunday. What kind of work does he do?
He is a commercial cleaner. Those are all Caldwell Banker Hubble Realtor offices. And he goes in at the conclusion of the day and wipes things down, vacuums, prepare the office so it's clean and presentable for the next day's work. He does it in conjunction with his grandmother, which I think I pointed out also in the stipulation.
Well, you said his mother is doing all the work. That doesn't let me know what that means. I don't know that means he works with his grandmother. I just read that his grandmother who's doing all the work will drag it fit into the company. So this is a privately owned business? Or
yes,
of his grandmother?
It's his cleaning. No. It's his cleaning business, and his grandmother has been pinch hitting for him so that they didn't lose the clientele. But it is Mr. Kennedy Atkinson's business.
Okay. Is he living with his grandmother now?
Yes, that's where he's been placed with his grandmother. That's where he's been house arrested to, is with his grandmother's.
Okay, and on GPS tether?
Yes, he is.
Okay, so what, on the days that you're presenting here, which is Monday through Thursday, 5 to 9, he's gonna be at all these 3 addresses?
He goes from one to another.
Okay, and on those dates and times, so I just want to make sure because it would have to be updated with JSG if I grant the stipulation for him to be at these addresses on Monday through Thursday, 5 p.m. to 9 p.m. And then he'll return home, and then again on Sunday from noon to 4.
That's correct, Your Honor.
Okay. I will grant the request for him to return to work under those conditions. We'll update JSG with these addresses, and he can be at these properties during those timeframes for the purposes of completing his work, and then he needs to return home. All other bond conditions will continue. Do you have any questions, Mr. Atkinson?
Yeah, there was a 4th address that I forgot to provide.
What address is that?
It's 822 Centennial Way. It's right next door to the 607 West St. Joe Highway location.
Okay, so that's in Lansing.
Yes.
Okay. Any other additions that you want to add or any questions that you have at this time?
No, not at this time.
I do, Your Honor.
Yes.
Ms. Emmons was concerned because of the house arrest about whether he would be allowed to attend meetings at my law office. And we also know that he has medical conditions and I wanted to see if with prior notice to Ms. Emmons, he would be able to go to required hospital meetings and to come to my office to continue preparations for his case.
Yes, I did see. Well, I didn't see that addressed here. Let's see. He may leave the house to attend medical appointments with prior notice to Ms. Emmons. And then I do see that it is addressed for him to go meet with his attorney. So yeah, I'm actually signing the order that you provided. I just updated it with the address that Mr. Atkinson just provided.
Thank you very much. Nothing further from defense.
Any additional matters for the prosecution?
Nothing further from the people. Thank you.
Thank you. You're all set.
Thank you, Your Honor.
Thank you.
Thank you. Mr. Knox. Yes, ma'am. On the record in the matter of the people of the state of Michigan versus Carl Michael Knox and file number 24-02343, counsel appearance.
Case Mark Arian appearing on behalf of the people.
Thank you, Your Honor. Assistant Public Defender Aaron Schroeder on behalf of Mr. Knox, who is present and now standing to non-rights.
Okay. Okay, how are you, Mr. Knox? I'm well, thank you. Okay, today was the date up for a preliminary examination. I do have a plea sheet. It says the people are offering for you to plead guilty to an amended count 1 of controlled substance use under MCL 333.74042B. That's a misdemeanor with the maximum penalty of 1 year and or $1,000. And upon entry of a guilty plea, they will dismiss count 2. Is that a complete and accurate understanding of what was offered to you?
Yes.
And you want to accept that offer, sir?
Yes.
Grab an advice and rights.
Honor, I think that's something we see. I apologize, Your Honor. Oh, that's not the time. Wait. Hang on. Is it? Well, you gotta, do you understand this, right? Then you're going to come to that. Yeah, the question. Your Honor, if I may approach?
You may. Raise your right hand, sir. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury? Okay, you can put your hand down. You have certain rights, sir, that you would need to understand and then give up if you want to accept this offer. First, I do have the advice of rights here and the information sheet. With today's date on it. Read this document. You understand the rights there? Can you speak up so we can hear you on the record? Okay, and this is your signature? You understand that you would have to give up each of these rights if you want to accept the offer? So you have the right to the presumption of innocence. You're innocent until proven guilty. You have the right to require the prosecution prove your guilt at trial by proving each element of the charge being brought against you beyond a reasonable doubt. You have the right to remain silent at trial and not have silence be used against you, or you can waive that right and testify at your trial if you'd like. You have the right to subpoena witnesses to testify for you at trial, and you have the right to present evidence that you believe show a defense to the charges being brought against you. You have the right to see, hear, and question any witness the prosecution calls to testify at your trial. You understand each of those rights that you would be giving up?
Yes, Your Honor.
Anybody threatening you to get you to give those rights up? And the promise is being made to you if you plead guilty today. You currently on probation?
Yes.
Out of circuit court? Where are you on probation?
Kowski. Sir, yeah. I'm thinking it's district.
You said Judge who?
Probation officer, council.
What judge put you on probation?
Oh, yeah, Aquaman, so
Circuit court? Okay. Until when?
3 months left.
Okay. I understand that by pleading guilty, it could result in a violation to your probation status. Okay, you also understand that by entering a guilty plea, it can result into a conviction that you may need to report to a future or current job. This conviction could also have impact on travel or immigration status that you may be seeking. So certain countries may prohibit you from entry because of this conviction. You understand that? As to the amended count 1 of use of a controlled substance, how do you plead? So because you believe you're guilty? Factual basis, please.
Thank you, Your Honor. Mr. Knox, back on the date on or about of August 9th of 2024, were you at a location of 5030 South Waverly Road?
Yes.
Okay, is that to your knowledge in the city of Lansing County, Bingham, state of Michigan? And at that time, had you been in possession of a controlled substance, cocaine? And had you been using that substance? And you knew it to be cocaine? And it's because you purchased it, is that correct? You got it? Okay. And you knew that that was something you weren't supposed to do, correct?
Correct.
All right.
Prosecution.
People are satisfied with the factual basis, Your Honor.
The court is also satisfied with the factual basis and I'll accept your plea or find that you may plead voluntarily and intelligently. Our schedule for sentencing is going to be October 18th at 9 a.m. with our probation department, so they can prepare a pre-sentence interview and provide you with a recommendation as to how you are to be sentenced. And you need a substance abuse assessment done, okay? Held on anything other than this in custody? Your bond was 3,010%, so you just didn't post the bond? Said you needed fingerprints. Did you get fingerprints taken care of?
Yes, they just did.
Oh, okay. Thank you. Are we addressing bond?
Yes, Your Honor. Thank you. Mr. Knox has been in custody throughout this case, as the court has noted, which would give him, as of today, approximately 21 days in custody. He has just pled to a non-assaultive misdemeanor, as in the sentencing, he is employed, he works and takes care of his mother. And she has been in the hospital and he does show up for court. He is on probation. He knows that he's gonna have to deal with that at some point as a result of this, but he fully understands that. I'd ask the court to consider him for the PR bond at this time. Thank you.
I'll amend the bond to 3,000 personal recognizance. All of the bond conditions will continue, and you must report to pretrial services. Sorry, you must report to probation in 48 hours in person, okay? No later than Monday. And then can get you set up for. Sorry. Oh, Monday is Labor Day, we're closed. No later than Tuesday. You have any questions? Now, don't let the long weekend mess you up and you forget, okay? No later than Tuesday at 9:30. Any additional matters for the record?
Nothing further for the people. Thank you.
What was that date for sentence? It was the 18th at 9 a.m. Is that correct?
Correct.
All right, thank you.
And this is his copy.
All right, very good. I may.
Yes.
Thank you. Copy for that. Second one to appear. Just make sure you get that from back. Give me a call when you get out of there. Yep.
On the record and the matters of the people of the state of Michigan versus Kristen McGinnis, file number 24-01883, and David Salas, file number 24-01882. Council appearances, please.
Good morning, Your Honor. Case Markarian appearing on behalf of the people.
Your Honor, Fred Blackman on behalf of both defendants, Mr. Solis and Ms. McGinnis.
Okay, these matters were scheduled for preliminary examination, but there was a motion, or they wanted to waive these to circuit court, but we needed to address the waiver of conflict, which the court does have a copy of in each file now. And so your party or your counsel, your clients still wish to waive their exam.
They do, Your Honor.
Okay, very good. And the people are waiving.
Yes, Your Honor. We'll unconditionally waive our right to an exam on both cases.
Okay, Ms. McGinnis.
Yes, Your Honor.
Okay, you understand your right to have a preliminary examination here in the district court.
Yes.
The purpose is to require the prosecution put forth evidence that would establish that they have sufficient enough probable cause that a crime was committed, and then probable cause sufficient to charge you with the crime. You understand that?
Yes.
And you want to unconditionally waive your examination?
Yes.
Anybody threatening you to do that?
No.
Has there been any promises made to you to get you to want to waive your exam?
No.
You understand that it's unconditional, so that means that if you get to circuit court, you don't like your offer, you can't change your mind and have your exam.
Yes.
Once you give it up, it's gone, and it's not based on any threats or promises, correct?
Yes.
Okay. Same for you, Mr. Salas. You understand that this is an unconditional waiver of your exam,
Yes, Your Honor.
and that's what you want to do?
That is correct.
Anybody threatening you to get you to waive your examination?
No, Your Honor.
Has there been any promises to induce you to waive your exam?
No, Your Honor.
Find over date September 11th. That's the date the circuit court's gonna get the file or files from the district court on both of these matters. Neither of you need to appear in circuit court for that date. Your next appearance in court is gonna be a free trial in circuit court. Mr. Blackman will be notified of that information, okay?
Okay, Your Honor.
Okay.
Okay, I have an address for you, Ms. McGinnis, on Tower Garden. Is that still accurate?
Yes.
And then Mr. Salas is Holloway. Is that still?
Yes, the 1706 Hollyway.
Okay, very good. A bond for Ms. McGinnis, 510%, that will continue. A bond for Mr. Solis is 2,010%, that will continue, as well as the no contact order. Any additional matters for the record?
Nothing further from the people. Thank you.
Nothing for the defense, Your Honor.
Thank you, you're all set.
Thank you.
You're welcome. On the record, in the matter of the people of the state of Michigan versus Lamont McDermott, file number 24-01757. Council appearance.
Good morning, Your Honor. Case Mark Heron appearing on behalf of the people.
Assistant Public Defender Sarah Donnelly on behalf of the defendant who was not present.
Recently.
I received messages from him, Your Honor. It seems there was a new bench warrant issued on, well, he's got a couple of bench warrants. He had a failure to appear down in Mason, but there was a new assault and battery allegedly from February. So his message essentially was that he wanted an adjournment. He wanted to take care of some business before he had to turn himself in on the warrants.
I'm sure bench warrant.
Okay.
Thank you.
Thank you, Your Honor.
You're welcome. Can they bring the file for the arraignment?
Yes, I set it here.
Name, sir.
On the record, in the matter of the people of the state of Michigan versus Richard Bruce Greenman II, file number 20-01645. Mr. Greenman, this is a file that you have a violation for and a bench warrant for failing to appear for an arraignment on a probation violation. I have a request and summons for probation violation. This is from June 13th. It states that you tested positive on May 24th for morphine in the amount of 248.39 nanograms per milliliter, and that on June 5th, 2024, you tested positive. It says 6 ma'am, 15.91 nanograms per milliliter, and morphine 643.33 nanograms per milliliter. And let's see what is this. I'm going to have an additional violation alleging that you tested positive on the 13th of June for morphine, results yielding 284.06 nanograms per milliliter. Why didn't you come for your probation violation arraignments?
Your Honor, I actually ended up going to inpatient rehab. I went to my outpatient to sign up, and they told me I should go to an inpatient facility. So I ended up going to Sacred Heart for 30 days, and now I'm in the RISE program. So that's something I should communicate with my probation officer. Well,
You have the right to have a contested hearing. You have the right to be represented by counsel at those hearings. If you're found to be in violation of your probation, as alleged, your probation status can be revoked. You can be sentenced to jail time, or you could be extended and you can have other oversight or programming added to the terms of your probation. Do you understand that?
Yes, sir.
Do you want to request an attorney to represent you?
Yes.
And you'll plead not guilty, and we'll get you connected with a public defender today so they can make sure they have your information, okay? So you're currently residing where, sir?
And right, recovery house, rise.
What's your phone number?
517-619-4314.
You can have a seat. We'll get you a next court date, which will be for your probation violation hearing, and then I'll see if one of the public defenders can do it and take it, okay?
September 9th at 1:15.
September 9th at 1:15, and we'll get you a notice in just a moment. Record in the matter of the people of the state of Michigan versus Joshua McCauley, file number 24-02329. Appearance, please.
Morning, Your Honor. Tom Martinez, appearing on behalf of the people of the state of Michigan.
Good morning, Your Honor. Assistant Public Defender Stephen Feigelson, appearing on behalf of Joshua McCauley, standing to my right this morning, Your Honor.
Okay. How are you, Mr. McCauley?
Excellent, Your Honor. How are you?
I'm well, thank you. Today's the date that's scheduled for preliminary examination of count 1, home invasion first degree, count 2, interfering with electronic communications. Count 3 is a police officer assault resist obstruct. Count 4, assault or assault battery, and then count 5, animals abetting cruelty to one. And we are running an exam today.
Your Honor, yes, that's my understanding. We do have the complaining witness ready to testify for witness.
Okay, any matters before we call witnesses?
No, Your Honor.
Just one, Your Honor. Well, two really. One, the first is that I think there are two witnesses today and asked those.
Registration is granted. Any matters for the prosecution?
No, Your Honor, case mark Aaron appearing on behalf of the people. We just have 2 witnesses on this one. I expect one of them, Officer Slovin, will be brief, but I do expect the other, the complaining victim, this agent will be rather long. I expect there's might be a couple dismissals left on the document if you wanted to handle those first.
Dismissals for what?
Failures to appear. And then
Which cases?
Marquise Washington. I don't have any of the necessary witnesses here on those, despite numerous contact. Monique Williams, my intent was to seek an adjournment, but I know that has been adjourned a couple times already, so I expect that might be a dismissal issue.
Okay, on the record in the matter of the people of the state of Michigan versus Marquise Washington, file number 24-02151, counsel appearance.
Good morning, Your Honor. Case mark Aaron appearing on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Eric Schroeder on behalf of Marquise Washington, who is present and now standing to my right.
Today was the date scheduled for preliminary examination on motor vehicle unlawful driving away, and there's no witnesses here.
No, Your Honor, the necessary witnesses, Josephine Adams and the enterprise manager, Tammy Kriegel, despite numerous attempts to contact and get them on board, have not appeared and are not willing to participate, so the people are unable to proceed.
With that being said, Your Honor, the defense is making motion for dismissal. Thank you.
Motion to dismiss is granted. It's granted without prejudice. You have the right to reissue the charge against you. You understand that, sir?
Yes.
Do you have any questions? We'll get you a copy of the dismissal in just a moment, okay? You're all set. The matter of the people of the state of Michigan versus Monique Williams, file number 24-01317, council appearance.
Good morning, Your Honor. Casey Markarian appearing on behalf of the people.
And good morning, Your Honor. Stephen Mills on behalf of Monique Williams, who is present and standing to my right at this time.
Okay, Ms. Williams, you have assault with a deadly weapon, domestic violence, and an assault and battery. And there's no witness.
No, Your Honor, the necessary witness, Ulysses Allen, has not appeared. I did receive, and so for the court's reference, Your Honor, I am admittedly just stepping in on this case. The case notes were not the best, and it seems the only way we can contact Mr. Allen is via email. I attempted to do so after speaking with the other witness, Jessica Banks, yesterday. I received email communications at 11:20 p.m. last night from Mr. Allen's claiming that he had just started a job today. So that's why he could not appear and he was unable to get out of it. So I would be requesting an adjournment. I know there have been a couple of adjournments granted on this, though we have no problem with dismissing and reissuing.
I don't see any adjournments on here.
There were,
I see. And I'll be clear, I don't see any adjournments by your request. I do see where Judge Ward handled the probable cause conference. That report to pretrial services leave for PE and waive the 21 days. I don't know Wednesday, what days is it?
Shelley put in here request adjournment job training. So I don't know who had job.
Someone had job training.
I believe that was the defense request at that point, yes, Your Honor.
and that is true, Your Honor. At the PCC, we did request because there was a problem. We're having job training on the day of the PE. It was rescheduled for July 24th, then July 24th. I was under the understanding or belief that it was because the prosecutor's office did not have witnesses at that time either, that it was them who made the request.
Okay, the May 10th court date, the 21 days was waived. It was moved to July 25th. And that 21 day or adjournment was based on the defense request. That the 25th date was changed because of the judge. I was not available.
Your Honor, I apologize. I did have an exchange with Ms. Williams. It seems we were scheduled for that day, and I think this may explain why there was no notes from the prosecutor at the time. But it seems like there was, I think, something with the dockets going on. I think the court, I think it was kind of a last minute change on things, so there was a little bit of confusion. Remember, we had it for the 24th, but it was not on the docket on July 24th. And I'm not certain what happened.
Judge Ward's staff set it for July 23rd, which is probably not an exam date for us or something.
Oh,
This says it was set for the 25th.
It said the 23rd, but in her handwriting, I see your handwriting crossing hers out, putting 25th.
Yeah, but Shelley scheduled it for the 25th.
Nonetheless, I'm just reading the notes. Judge Ward's handwriting said July 23rd. I see then Addie Nash crossed that out and put the 25th. And then on July 10th, there was a change in my schedule, so it's reset to today's date. So I don't see where the prosecution ever made the request. The request is because the person has a job or started a new job.
Started your job today.
back in May, Your Honor. And I understand what was just put on the record. My communications with Ms. Petrosky at the time was that there were some major witness issues regarding people being on board or not. The fact that this was going on since May at this time, Your Honor, I believe we're just prolonging the inevitable at this point, Your Honor. I believe a dismissal and reissue, if this is really what people want to do. My client understands that it could result in charges being reissued, but since this has been going on since May, Your Honor, there's already a misdemeanor off on the table, which we're not willing to accept either. The people's true veracity in going forward with felony, I think.
It was going on since May, but she was the one who
She did, Your
pushed
Honor.
it out to July.
we didn't want to set out to July. Unfortunately, that's just the way that it was.
That's how ours, we,
Yeah.
you know, just get to push it out and then you get a next date. The next date we had available was July. That was on the defense. It wasn't on the prosecution. I don't know what Ms. Petrowski shared with you, but it sounds like they've had communication recently. Is it the prosecution's intention to reissue this if this is dismissed?
That would be our intent, Your Honor, if I may.
Yes.
Not to disparage anyone at our office or anything like that. Ms. Petrowski is a different prosecutor and I'm taking over this docket now. Every case that I've had that Ms. Petrowski handled prior, victim contact has been hit or miss. So I'm just asking for a one-time adjournment to allow myself a chance to contact this victim, as he did communicate with me last night, a few 5-6 hours after I sent him an email. And I did communicate with Jessica Banks, who also witnessed the alleged felonious assault here too. So I have 2 witnesses that I could provide if I'm just allowed a little time to comment.
I'm not dismissing it. This is just creates more work for the court to reissue, then issue it again. And I'm on call this week. It's coming right back to me to review this again. Then likely see her this weekend to rearrange it. Do you want to come in this weekend to be rearranged? I didn't think so. It's a holiday.
All right, if we could just request, if we set it on for 2 weeks, at that point, people will be able to get witnesses out. Witnesses won't come, we'll move for dismissal at that time, and then the case will be resolved.
I don't know if it'll be 2 weeks, but we'll set it for the next available day.
I'm fine with a short adjournment, Your Honor. I have no problem putting on the record that this would be the only adjournment I would request. I think have no problem making that big.
October 18th.
I don't anticipate this actually running in 2 weeks, Your Honor.
October 18th at 9 AM. Get your copy of your notice to appear. Any additional matters for the record?
Nothing further from the people. Thank you.
From the defense, thank you, Your Honor.
Okay, back on the record and the matter of People versus McCauley, and we're ready to call witnesses.
Yes, Your Honor, the people are ready to proceed.
Okay. Answer the sequestration order. You have 2 witnesses.
Yes, Your Honor. Officer Alex Slovin and complaining victim Adrian Burke.
Okay, so
Calling Officer Slovin first, just because I expect it to be pretty brief.
he's waiting for a copy of his dismissal. Is that what's on?
Oh.
Sir, what's your name? Oh. Where is it? Who is this attorney? Schroeder back. Yes. Excuse me? No, you can have a seat and wait. I had this issue last week. I'm not chasing people down here.
Do you want me to go get him from the hall, Your Honor, or is that we're waiting for something?
I'm waiting for Ms. Schroeder.
Sorry.
Thank you. Okay, on the record in the matter of the people of the state of Michigan versus Marquise Washington, file number 24-02151. Apparently, the witness has appeared.
She has, Your Honor.
That's what
My
I was told.
understanding, she's already been sent away and didn't want to testify or participate in this case anyway, so last contact I have.
Is she
with
here?
her. We want to run the preliminary exam, Your Honor.
I'm confused. My issue is I signed this, I gave it, and then I was told the witness appeared. So is the witness here or no?
My understanding, she did appear, Your Honor, much to my surprise. Every contact I had with her is that she wasn't going to appear, she wasn't going to be available. I explained to her that that would result in a dismissal, and it was my understanding she wasn't going to appear.
Your Honor, may I make a statement?
Yes.
Thank you. It was brought to my attention by the court staff that Ms. Adams, on this file, Ms. Adams was in the hallway. That's the first I had heard this morning that she had appeared. I went in the hallway, I confirmed it was her. I explained to her that you had already called the case, that we didn't know she was present, the case was dismissed. I said, would you like to see the case reissued? Do you not want to see the case reissued? Tell me what you want to see happen. She indicated to me that she was not interested in moving forward with this case and that she does not want to proceed with this case. So that's the information I've got.
Thank you.
This one. Yep, you're welcome.
That was the same as every contact I had with her.
Thank you. We're gonna get you a copy of your dismissal so you can get out of here, okay?
Thank you. Yeah. Let's see.
I don't know. Well,
Yeah,
I
sorry.
just want to know what we're going to be doing, you know.
Okay, back on the record in the matter for Mr. McCauley, you can call your witness.
Thank you, Your Honor. Chief of Police Officer Alex Slovan to the stand. Thank you.
Do you solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury?
I do.
Thank you. You can have a seat. State your first and last name, spell both.
Officer Alex Sloman, ALECSLOBIN. Thank you, Your Honor. Good morning, Officer Sloman.
Good morning.
Are you currently employed?
I am.
Where?
Lansing Police Department,
How long have you been employed with the Lansing Police Department?
just shy of 8 years.
What is your current rank and assignment?
I am a road patrol officer.
Could you please briefly describe your duties as a road patrol officer?
On to calls for service, and conduct proactive policing.
In your time as a road patrol officer, have you ever been called to or assisted in a allegation or someone who's resisting arrest?
Yes.
How often?
Jackson, is there relevance to this?
That's relevant.
Slang foundation, Your Honor. I can move on.
Okay, thank you.
Officer Slobin, let me take you back to the date of August 8th, 2024 at around 11:25 p.m. Were you on duty in that same capacity that you described as a road patrol officer?
I was.
At some point, did you receive a call to be dispatched to the location of 508 North Foster Avenue?
I was.
Is that in the city of Lansing,
It is.
county of Hingham,
Yes.
state of Michigan?
Yes.
What does it mean to be dispatched, or could you describe what you were dispatched to?
It was a troublesome subject complaint.
What's a troublesome subject complaint?
They generally involve two parties that are disagreeing over something. They can turn into a myriad of different calls.
And at some point, did you make contact with the suspect of the troublesome subject?
I did.
Who was that person?
Dr. McCully.
The person that you've named identified as Joshua McCauley. Do you see him here in court today?
I do.
Could you please point him out and identify him by an article of clothing he's wearing?
Wearing a black suit coat with a blue and white tie.
Your Honor, please let the record reflect Officer Slobin has identified the defendant.
Any objection?
No, Jackson, they will cross him.
So noted.
All right, so 11:25 p.m. you arrive at 508 North Foster for a troublesome subject, the defendant. Is it dark, light, or is there, could you just kind of set the scene for us a little?
It was dark with only light coming from the light on the front of the house.
And where was this troublesome subject located, if you located?
He was sitting on the front porch of that residence.
Did this subject, the defendant, tell you whether or not this house was his or someone else's?
He did not.
Did he indicate that he lived there?
No.
So what happens when you make contact with him? Is there a dog?
There was a dog next to him. Officers were contacting him at that time, asking what was happening. At which time he began hitting the dog. I advised him to stop or he'd be arrested for animal cruelty.
Was that, I mean, were you in uniform when this happened?
I was.
Plain to see for everyone?
Yes.
Was this a lawful command you were giving him to stop hitting the dog or he would be arrested?
Yes.
At some point, did you get a call or an update over the radio that charges were being sought against this person?
I had spoken to other officers on scene.
What happened?
Advised of that.
What happened at this point?
He was asked to stand up and get off the porch. At which time he said no and grabbed the dog by the neck. It's a way to shield himself to stop officers from approaching him.
Let's talk about this dog a little, since you're saying he was used to shield him. Is it a large dog, small dog?
The pit bull type breed appeared to be somewhere between 80 and 90 pounds.
So he was using a pit bull to shield him, and he didn't comply with your order. Is that fair?
Yes.
What happened after he didn't comply with your order?
Officers approached and attempted to grab onto him, which time I pulled my taser out and advised him he would be tased if he failed to comply. I noticed that he was starting to come off the porch with the force the officers were using. At that time, I holstered my taser, grabbed him by his left wrist, and assisted him further. But at that time, he was also trying to, he let go of the dog and then began to grab onto the railing of the porch.
So he was grabbing onto the railing. What would you describe this as?
At the same time, to not
with officers as they're pulling them away from the dog.
To be clear, you gave this order when you were in uniform.
Yes,
This order you gave, it was a lawful command.
yes.
And how close to you was the defendant when you gave this order? Could he hear you?
Within 10 feet.
Karen, I have no further questions for the witness at this time.
Yes, Your Honor, thank you. Good morning, Officer Slow.
Morning.
So you've been with LPD for 8 years, is that correct?
Just shy, yes.
Okay. And you were on roll patrol the night of August 8th, is that correct?
Correct.
And you got called out to Foster Avenue in Lansing, is that correct?
Correct.
And have you been to that house on a call before?
I had not.
And did you make contact with anybody else there besides the person on the front?
No.
And have you met that person on the front porch before that night?
No.
Now, how close were you to the city? 10 feet away?
At the time he was advised he was under arrest, yes.
Was it light enough for you to see who that person was?
Yes.
Can you describe what they were wearing from that night?
He had a black or blue hat, glasses, with an orange shirt.
Can you see how tall that person was?
I used to sit down.
Did he have a full head of hair, short head hair? Can you describe what his hair was like?
He was wearing a hat at that time.
Did he have a beard? Any other distinguishing features of that person?
Beard.
Did he give a name to you?
I did not hear the name.
Okay. And you said you didn't ask whether that was his home or whether he was visiting somebody's home. So you're not sure why he was there. Is that correct?
Correct.
And you said as you were getting under arrest, you tried to grab onto the railing. Was it on the left side or the right side?
It was on his right side.
Okay. Do you think you could have been doing it to try to stand up and help cooperate with you? Why do you say that?
He was grabbing an attempt to prevent officers from pulling him off the porch.
Was he saying anything as this was going on?
He had already told us no, he wasn't going to stand up.
But after, as you guys were using force, did he say anything to you at that point?
That I don't recall.
Okay. I have no further questions for Officer Slogan. Thank you.
Any redirect?
Briefly, Your Honor. Just to clarify the comments about when he did or didn't say no, had you already given him a lawful command at that point?
Yes.
Did he then say no?
Yes.
Did he then resist your arrest?
Judge, I think he's leading. He's leading. My next question.
One, he's already testified to all these things, so I'm not
He's already
suggesting.
testified, he's just trying to redirect, so I'm gonna allow it.
Did he then resist your lawful order
Yes.
while you were in full use? Thank you for the question.
Thank you, Officer Slaughter, you may be excused.
Take off.
Next witness.
People call Adrian Perfect.
Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes.
You can have a seat. There is a microphone that's in front of you, and the young lady behind you, she's my court recorder. That microphone in front of you is for the purposes of her being able to pick up everything on the recorder, because everything in the courtroom must be recorded. It does not amplify your voice, so your responses must be loud and clear. And they must be verbal, so you can't do head nods and head shakes to yes or no questions, okay?
Yes, Your Honor.
Okay. If there's an objection from either attorney, you will stop answering. I need to make a ruling on that objection, and then I can advise you as to whether or not you can give us that answer. State your first and your last name, then spell both.
Adrian Kirk. ADRIENNE KIRK.
Proceed, counsel.
Yes, Your Honor, thank you. Good morning, Ms. Kirk. Ms. Kirk, are you currently employed? Do you know or are you familiar with the location of 508 North Foster Avenue?
That's where I live.
That's your home.
Is that a yes?
Yes.
Kirk, I'm gonna get right into it, although I know this might be a little difficult for you. I don't want to take up anybody's time. On the date of August 8th, 2024, did you at some point make contact with police?
I did.
What was that regarding?
That somebody came into my home.
Break that statement down a little bit. You said somebody came into your home. Do you know who that person
When
is?
Josh came into my home and he was not invited.
Okay, so you've name identified someone as Josh and you seem to be looking at somebody in court. Let's back up a little first.
Sorry,
Do you know this person named Josh?
I never met him before.
Have you
That
seen him
night.
before?
Not before that night.
How did you know that this person was Josh that night then?
When I was out with the dog, he had a dog. And they were frolicking and we just met and I just said you should take them to a dog park or something like that. And it was getting late, so that was that. And I went home. That's it.
Let's back up a little bit. I'm just trying to make sure we can identify the suspect here.
Okay.
Do you know, or when you were making contact with this person that you know is Josh, did he at some point tell you his name or can you remember his face or?
Yes, he told me his name was Josh and that he lived up the street from where we were standing. We were actually standing in the middle of the street. My house is at 508. He was at 523. That's where he lives at 523. But I had never met him before and I had never met his dog before.
Now, this person that you know as Josh, who you met that night, can you remember their face if you saw them again?
Yeah.
Do you see
Yes.
them? Do you see them in court here today?
Yes,
Could you please point him out and identify him by an article of clothing he's wearing?
that is Josh in that blue tie.
Your Honor, please let the record reflect Ms. Kirk has identified the defendant.
The objection.
No, not costly, Your Honor.
ID is noted.
Ms. Kirk, you stated that you were watching a dog. Whose dog?
My friend, Miss Peggy, she lives on the corner. Her name is Margaret Murphy. And I was watching her dog while she went up north to visit with family.
What was her dog's name?
Rambo,
And around 11:30 or 11 o'clock that night, do I understand that you took Rambo outside?
no, it's more like 10:40, around the 10 o'clock hour.
So around 10 o'clock, you take Rambo outside.
Mhm.
Is this when you
Say
make
yes.
Yes,
is this when you make contact with that Josh person?
yes,
Okay, explain that a little bit to me. Is he just walking his dog on the street? What's going on?
yes. I'm not 1,000% sure as to how we were in the middle of the road, but the dogs were frolicking and they got a wee bit tangled up. And after a couple of minutes of just kind of talking and trying to untangle the dogs, he had told me what his dog's name was. And that's when it dawned on me, that, oh, I think this was a dog that Miss Murphy told me that knew his dog. So
What's his dog's name? Do you remember?
Maximus.
Have you seen Maximus before? Before this
No.
night? No? So, if I'm understanding it correctly, people in the neighborhood know Maximus.
Yes,
When you get tangled up in the street, who approached who? Who made contact with who?
the dogs did.
The dogs approached each other.
Yes, and then I suggested that we just go into the fenced-in area where Rambo lives, which is across the kitty corner from where I live. And basically 6 or 7, 8 houses down from where he lives. But the dogs had met before.
So the dogs knew each other, approached, and then you suggested going into some fenced-in area. Was that a
Uh-huh.
neighborhood fenced-in area? Was that someone else's home?
No, Rambo had just gotten a new fence, literally that week.
So at your neighbor's house that
Yes.
owns Ranch.
Yes,
Oh, is that down the street, close to your house?
it's kitty corner from where I live.
How many houses away? Do you know?
1, 2,
So there's a house separating yours and hers.
there's a road. And then a house. And then
Let me ask it this way. How far from her house in that fenced-in area where you were playing with the dogs is it to get to your house, if you can guess? Half mile, quarter
it's
mile,
150, it's about 150, 170 feet.
150, 170? At some point, did you try to end this interaction with Josh when the dogs were playing in the fenced-in area?
When I suggested that we go into the fenced-in area on the street, was the only time I suggested that. And then it was getting dark and we went inside. He went his way, I went my way. And I had suggested, because the dogs were frolicking, having a good time, perhaps maybe we could, if he knew of any dog parks or anything like that, that'd be great. But that was it. And I went home.
Did you invite him to come over with you?
No,
Did you in any way indicate, hey, come over to my house with me, we'll go take the dogs home?
no,
So based on your perspective of the situation, once they were done playing in that fenced-in area, you suggested maybe meeting up at a different point. That was it. Is that
yes.
fair? What happened after you suggested meeting up at a different point?
I went home and I don't know where he went.
Did he follow you? Do you know?
No, I don't know.
So safe to say, you two separate.
Yes,
You went home.
yes.
Then what happened?
Then about 45 minutes later, he showed up at my front door with his dog.
Did you invite him over?
No,
Was the door unlocked?
the door was locked, but I didn't hip check it. The door was locked. It's a very heavy door and I did not close it all the way.
So the door was closed, but not.
It
unable
wasn't
to-
latched.
Okay, so not latched. Did you open the door for him?
I don't recall. I don't think so. The door, he just kind of came in and said, here. He came in and was like, here. And I want you to give, here's water for the dogs. Which I thought was a nice gesture, but I hadn't invited him in. That's how he entered the home.
So he let himself in. Did he open that door?
I don't recall him opening the door. The door opens, the screen door opens one way and then the main door opens another way. And I just can't recall. I don't know if you've seen the dog, but his dog's very large I didn't, I was more concerned on if the other dog was gonna get out. But I did not invite him into my home.
I know it's been almost a month since this incident happened, so I just want to discuss exactly why you're unable to recall now. Is that correct? Could you see the door when he entered? Were you looking
Yeah.
at it?
Yes, yes,
So you didn't have your back turned, you were looking at the door.
I believe so. I have bells on my doors. But I believe that, I mean, I wasn't sitting there looking at the door waiting for somebody to come in, if that is what your question is.
Yeah.
Okay,
So you weren't keeping a constant eye on the door,
no,
and at some point, this person that you didn't invite over makes his way inside.
yes,
What happens after he makes his way inside?
sorry, give me a second. So when he came inside, he came in, he had a bag and he said he brought water for the dogs because they had to have purified water. That's when I was like, okay, I had no idea really what was going on. I was like, what? I didn't really know what was going on. And these dogs have to have purified water. Give that Rambo, and mine doesn't need any. And then he punched his dog in the face. And I didn't give my dog any.
Let me stop you there.
Thank you.
So we're at the point where he punches his dog in the face after this promise of giving them water or whatever you want to call it. Okay?
There was an order to give the purified water instead of the water from the faucet to the animals.
And then he at some point punched his dog.
At some point,
Or
that
right-
was the
right
first
then?
time he did it, yes.
What happened after that?
He continued to do so, but he didn't just do it with his hands.
What did you do when he started punching his dog?
I was standing up the entire time. Then he ordered me to hit his dog.
Try to get you to hit his dog too.
Yes,
Did you kick him out? Did you tell him to leave at this point? What happened?
I didn't know what to do at that point. He wanted to have a cigarette, and I told him he couldn't smoke in the house, thinking that he would be gone. So I went outside. I was standing up the entire time he was there. We went outside on the back deck, and that's when it got like really weird, like really, really weird.
What do you mean?
He was sitting down, striking his animal, again, ordering me to hit his animal. His animal, Maximus, went to the other yard. To a fence that was standing up, that is now not standing up anymore.
Let me just try to bring you back to what
Okay,
happened
I
at
was
the
standing
house
in the corner, okay.
between you
We
and
went
Josh.
outside.
Okay.
And I thought, okay, we're okay. Then he started urinating all over my back deck, and then
The dog?
no, no, Your Honor,
Who was urinating on your back then?
Josh,
And then what happened?
I went inside to be certain that I could be taking care of Rambo, and he and his dog then came back inside. Then he sat down, and that's when everything like got really crazy.
What do you mean everything got really crazy? At some point, did he assault you?
Yes,
At some point, did he spit in your face?
yes,
Objection leading, Your Honor.
it's not leaving.
There's an objection.
So,
The question's relating. What is there a reason?
I can rephrase, Your Honor. I was just trying to lay a little foundation. I think we're having some issues. But I can rephrase.
Objection.
She stated
sustained.
she was assaulted. It's-
Thank you.
How were you assaulted?
I was trying to call 911. Josh was standing over me. He grabbed my phone out of my hand and threw it against my kitchen wall, which is about 10 feet from where he was standing.
Let me stop you there for a moment. You said that you pulled out your phone and you were trying to call 911.
Yes,
Was he aware that you were trying to call
yes,
911?
I'd already asked him to leave.
So you asked him to leave, then you tried to call 911. What happened next?
Grabbed my phone out of my hand and he threw it against my kitchen wall. But we were in the living room, this one, closest to my front door. But it's not even 25 feet from the front door to the back door, or to the kitchen wall.
Did
He was
your
standing
phone, were you trying to complete the call? Where were you at in the call? Were you
I
had
said,
you
I'm calling
dialed
911,
in?
yes. And he grabbed my phone and he threw it,
Did your phone break?
yes, shattered.
What happened with the phone after that? You know?
It laid on the floor,
Did you try to use it again?
yeah,
Were you able to?
yeah.
Was this before or, well, I mean,
Yes.
at some point, did Josh leave?
After he hit in my face,
Describe that to me. When did he spit in your face?
the second he threw my phone at the wall, you have to leave on his way back from like this motion. I don't even know how to explain this. And he just, and then spit in my eyeball.
Oh, I know this might be a little bit of an odd question, but did you ask him to spit in your eyeball?
No,
Fair to say you didn't want that to happen.
no. Oh, yes, it's fair to say that I did not want that to happen.
What happened after he spit in your face?
Spit on him.
Why?
It was just my reaction.
Then what happened?
Yeah. He wiped the spit off of his chest. Because he's a lot taller than I am.
When, if ever, did he leave?
Shortly after that, when I opened the door and I locked the screen door so I would open and stay open. And I was screaming for somebody to call 911. And then he was outside and I slammed all the doors and locked them all. And then got a hold of 911. But he was trying to get him.
Please continue. You said he did something
Sorry.
about.
Getting him out of the house was at least 5 minutes after he spit on me or at me after he broke my phone. It was at least 5 minutes
Before he left.
before I could even get him out of the door.
This whole 5 minutes, what were you doing to try to get him out?
I don't recall exactly. I know I was saying you weren't invited here and I don't want you here. I need you to leave. That's all I remember.
Or at any point that night, did you invite Josh over?
No,
At any point, did you see him open your door to try and get in the house?
no.
Somehow he just entered.
They closed the door all the way. Sorry,
You
guys.
need a moment?
No, I'm okay. If you step with me like that.
Thank you, Your Honor. I have no further questions for the witness at this time.
Prosecutor.
Good morning, Ms. Kirk.
Good morning.
Turn your attention back to August 8th of this year. So you were dog sitting for a friend, is that correct?
Yes,
And that name of that dog was Rambo, is that correct?
yes,
And you've never met the individual you saw with the dog that night before, is that correct?
your client?
Yes, the person that you saw with the
I
dog.
have never met him.
And have you seen that dog before?
No, I have never seen that dog before.
So you said it was about 10 o'clock at night, is that correct?
I said, yeah, it's around twilight, so it could have been anywhere from 9 something to whenever. I don't know what the mean cycle
Okay.
is like.
So late evening, early night?
Yes,
Okay. And you were out walking the dog, is that correct? Your dog, Rambo, is that correct? How often do you watch Rambo?
I was going to get the mail.
Okay.
From Rambo's house.
Okay. And then you're gonna walk Rambo or just go back?
I
to
wasn't going to rock him. I walked him across the street with me. Over to me.
Okay. And you had you walked Rambo before that?
Yes,
And as you're getting the mail from Rambo's home, you run into another dog and that dog recognizes Rambo, is that correct?
no, it's not.
So what happened? That's the way I understood your testimony when you spoke to Mr. McCary.
I was in the middle of the street. And the client was with his dog. And they were getting friendly. And
So the dogs were getting friendly.
the dogs were, yes,
So the interaction occurred because the two dogs
yeah,
started recognizing each other and went over to play with each other, is that correct?
yeah.
Okay.
Yes, sorry.
And from there, how long did that interaction between the two dogs and you and Josh last?
I don't know exactly how long. Neither one of us had our telephones.
But it was a short conversation,
No, it wasn't too short because we ended up,
10 minutes, 5 minutes, half hour, how long were you standing?
we were standing in the middle of the street, sir. It was maybe about a minute and a half before, or 2 minutes before I suggested, once I found out who his dog was, maybe we could go over because Rainbow has a new fence
Right.
in the yard.
So
That
you
is,
suggested to go to Rambo's porch, is that correct?
yeah,
Why don't you just go there then? What prompted you to do a detour?
because I was watching Rambo for the first time and I didn't know that they had known each other. I don't know what your question is.
So you meet Rambo and this other dog in the street. You suggest to the owner of that.
I
dog-
met,
Just, I'm not having an answer. I haven't.
Let him
gotten-
ask the question.
I haven't gotten to my question. So, and then you suggest to go to the park, you suggest to go to Rambo's porch. Why didn't you go then when you made the suggestion? What do you do next? That's my question. What
okay,
happens
so if I'm hearing you correctly.
Yeah.
You said that I've never met Rambo or the other dog.
Not
That's
when-
how you phrased it, I believe. Sorry, I just want to be.
What
clear.
happens next? Why don't you go to the Rambo's porch? Where do you go next after you say, hey, let's
We
go?
were in the middle of the road. And so I said, oh, that you guys are friends because his dog had been on.
Still not
walks.
what I'm asking you. Man, what I'm asking is, you say to my client, let's go to Rambo's porch. As you're leaving the street, where do you go next? You go to Rambo's porch, you go to your house,
No.
you go down the street, what happens next?
We didn't go to Rambo's porch. We went to the fence and.
Which fence do you go to? That's what I'm asking. Where do you go? What's the next?
At where Rambo lives.
So you go to Rambo's house.
Yeah.
Okay.
Yes,
And how long does, and you play, and they play inside that fence, how long does that?
maybe about, not even 10 minutes.
Okay, and then you go back to your home after that, is that correct?
Yes,
Okay, were you having any alcohol or any
No.
drugs that night?
no,
And then you offer my client your phone number so that you can meet up with him later to go to a dog park?
no, I did ask him if he knew of a dog park that I could take, that we could take the dogs to because they seem to be getting along very well.
And neither one of you had your phones, is that correct?
Correct.
So do you offer to say, hey, let's Did you say let's go now, or did you imply let's go tomorrow? I guess I'm trying to figure out.
No, I just said my house is right there, and then I went home.
That was my question. To go, when you wanted to take Rambo to a dog park, were you planning to go that night? Were you planning to go the next day? What was your intention? You said, hey, let's go to the dog.
My intention was, do you know of a dog park that we could take the dogs to? It wasn't that night.
so
It was,
So you weren't making an invitation to go to a
No.
dog park in the future? Okay.
well, oh, yes, I was making an invitation for the future, but it wasn't at 11 o'clock that
So
night.
it was the next day. That's my question.
Oh, no, it wasn't the next day. It was whenever.
Okay. Same concept. So you go back to your home, is that correct?
Yes, I did.
And at some point you said the dog and Mr. My client come back in, is that correct? Over to your house. How long ago did that last after you left him at Rambo's house? Does he come to your home?
I'm sorry. I didn't hear.
You
what
go
said.
back to your house, correct? After you go to Rambo's porch. From that time frame, how soon after that does my client come over to his house with his dog? Was it 5 minutes later, 10 minutes later?
Yeah, it's 25 minutes. It's about 25 minutes, almost a half hour later.
Okay, and you said that your door was partially open. Can you explain what you mean by that?
My door wasn't partially open. My screen door was closed. My screen door is not locked.
But I got you.
My door is a very heavy door. It was locked, but it wasn't pushed all the way in at all for me to, I didn't check to see if it could be pushed in.
I got you. But you don't recall how he got in, but is that correct?
No, I recall how he got in.
You said you don't know whether he walked in or how he got in. You just said on Mr. McCarron's testimony, you don't recall whether you opened the door from or how he got into your home. Is that correct?
I guess if that's the way you want to spin it, but that's not.
I mean, I can ask Ms. Nash to replay the testimony. but
You
that was-
could, but the questions are two different questions as well.
Well,
All
you're
I'm
under
saying
oath right
is,
now, and I'm concerned you're perjuring yourself right now.
I'm not perjuring myself whatsoever. If I open the door or not open the door, it didn't matter. He knew he was not invited there. And when he walked in there, I said.
I haven't asked the question.
Oh, I'm just saying to you, I'm not.
I asked that
I'm not
none of this be
tracking.
taken into evidence. I haven't asked the question. I understand. Wait for my next question. Roughly. So he comes over to your house, and you said you were inside your house. Is that correct? And then some point,
Yes.
Yes,
at some point you go out to the porch. Is that correct?
yes,
And were you drinking out on the porch?
no, he was.
What about any alcohol, drugs, or anything like that?
No, he was out there, he was out there
Smoking a cigarette.
and drinking.
And you said all this lasted about 5 minutes inside your house. Is that correct? What during this whole how long did the incident last inside your house? When was it there? Was it a short?
How long was he there or how
Yes.
long did it take for him
How
to,
long was he in your home?
at least maybe 25 minutes?
Did he let you? Did you let him enter the home?
He was not invited in the home.
Did his dog come in the house?
Yes,
What happened when you were out on the porch?
he was sitting on the chair and urinating all over himself while his dog was pushing down a fence. And then he put his hands on his dog. And
Was he putting his hands on his dog because his dog was being disobedient? Was he trying to discipline his dog?
his dog was not being disobedient. I don't know how your client is just.
But the dog wasn't acting under bad behavior. Is that your testimony correct?
Objection, Your Honor, relevant.
The question was the dog wasn't acting obedient to the.
Right. Yeah. It is relevant to determine whether there was a how this alleged assault occurred between my client and the dog.
Your Honor, I understand animal
I don't think
cruelty
it's been, is it, oh, we're talking about the,
is one of the charges, Your Honor, but we're here for a
Fine.
preliminary exam, so we don't need to.
we don't have to address that, that's a misdemeanor.
But it does go to credibility too. And that's what I'm trying to get.
whether well, she testified the dog wasn't being disobedient, so you're asking another question?
I'm confirming that's what you said. She was kind of, and that's what we were getting at when we made the objection. So I could
She
be
was,
wrong.
no, the question prior to that was it possible that he could be disciplining the dog? I think she was very clear the dog wasn't being disobedient, and you followed up with another question. So
I can
it
move
really
on.
should have been an objection to ask and answer.
I'll move on.
Thank you.
No, when he's out on the porch, does he come back and go home a second time? Roll call.
Yes,
And you said you called the police, is that correct? That night? How long did it take for the police to arrive?
I attempted to call the police
Did you actually call the police then?
after the client was out of my home and I found my phone.
Okay. First we saw at the home, can you describe what they were wearing, what they looked like that night?
Sure. He was wearing, I'll start with his shoes. He was wearing a pair of Nike high tops, white, pink Nike swoosh, Spartan green. They were really nice looking shoes. Yeah, black pants and a hoodie and blowfish shirt that was pixelated with 4 characters on the front.
Can
It
you
was
describe,
yellow shirt with glasses and a black hat.
did he have a beard or anything like that?
Did he have a beard?
Beard, was he clean shaven or was he hair on his face?
His face looks similar to what it looks like now.
Okay. So I don't know what that is. Did he have hair on his face?
Yeah. Yes,
You know how tall that individual was?
about 6'3".
All right, no further questions, please.
Let me redirect.
Yes, Your Honor. Kirk, I just want to clarify the timeline and how the defendant got in their house. Okay, let's start with the time. Under direct examination, you said that this interaction with the dogs in the street that started at about what time?
Like twilight, so it was like between 9 and 10. So sometime between 9 and 10.
So sometime between 9 and 10, the dogs start playing in the street.
Is that a yes?
Yes,
Then, for about 10 minutes, is what you testified to on cross, where do they go and play?
at Rambo's in the corner.
Not at your house.
No,
Okay, after about 10 minutes of playing, what happens? Do you leave?
yes.
Where do
We
you
both
go?
left. I took Rambo back home with the mail and we went to his house.
Or wherever? Is it fair to say you don't know where you are?
I have no idea where he went.
Step out, or I'll take your phone. Sir, no, you need to step out now.
I don't know where he went.
Okay, I got you. 1 second.
The gentleman can come back because it was not his phone.
Yeah, I don't think it was this one.
Please make sure your ringer is off though, sir.
I'll turn it.
Hey, proceed, Your Honor.
You may.
So you two separate after the dogs play at Rambo's house. About how long after that is it before the defendant just walks into your house?
30 minutes, 25, 30 minutes.
You recall what time police responded?
I do not, I know it was before 11 o'clock. I believe it was before 11 o'clock.
You believe it was before 11
Yes.
o'clock, or you know?
I don't know for certain.
Could it have been after 11?
It could have
So
been, yes.
sometime around 11 is when they were stopped.
Yes,
Now, on direct examination, you stated that Rambo's house and your house are about how far apart?
150 feet. 200 feet, they're right on the, it's on the corner. I can walk over there barefoot, like it's just across the street.
At any point, did you give the defendant permission to come over to your house after you left Rambo?
No,
Okay. And at some point, he did show up about 30 minutes later, and you described 2 doors on your house? Is that what
Yes.
I'm understanding? Okay. So we have a heavy door, the front door,
yes,
and a screen door.
yes,
Screen door was closed.
yes,
Front door was tried to be closed, but it wasn't quite latched.
correct, yes,
At some point, after the screen door is closed, the defendant and his dog then just make their way into your house.
yes,
Did he have permission to do that?
no.
Now, when you first notice the defendant and his dog coming into your house, who do you see first, him or his dog?
His dog first,
So his dog comes into the house first.
yes,
Ms. Kirk, do you have dogs?
yes.
Are you familiar with
Well,
dogs?
I'm familiar with dogs, yes.
Do you know any dogs that can open a door?
No,
Okay, so the dog comes into the house first, and then who follows?
Josh,
The defendant. No further questions. Thank you, Your Honor.
This witness be excused.
Yes, Your Honor, this witness may be excused.
Okay, thank you, Ms. Kirk, you may be excused. Thank you, Your Honor. Any other witnesses?
People have no further proofs, Your Honor. People are.
This is the defense calling witnesses.
None for
today.
exam today, Your Honor. Thank you.
Yes, Your Honor. Thank you. As Your Honor is well aware, we are here for a probable cause conference. The standard for today is probable cause. It's the lowest standard in our criminal justice system. And what we're here to prove is that the defendant has been accused of 3 felonies: home invasion, first degree, interfering with an electronic communication, and resisting and obstructing an officer. We have proved by a probable cause standard that those crimes did happen, and he's the one who committed them. Your Honor, starting with Officer Slobin's testimony first for count 3, resisting and obstructing. Pursuant to criminal jury instruction 13.2, there are 3 elements that I had to prove. First, that the defendant resisted, obstructed, opposed, endangered, assaulted, or did something of the like to Officer Slobin when he was performing his duties. Specifically, I would argue that the testimony supports the defendant resisted, obstructed, and opposed Officer Slobin after he gave him a lawful command, knowing or having reason to know that Officer Slobin was performing his lawful duties at the time. We heard testimony that he was right in front of him. He was wearing a uniform. He'd given commands to stand up. He was told no. Then he was told he was being under arrest. He was told no again, pulled up. Taser got out, but not used, and had to struggle while the defendant was grabbing the railing to take him to the ground to get away. Your Honor, it's clear cut resisting and obstructing from that testimony. Moving on now to, I'll go count 2 next, Your Honor, interfering with an electronic communication, criminal jury instruction 35.1. I prove that the defendant prevented, obstructed, or delayed an authorized communication through a telephone line. That he did this willfully and maliciously. Your Honor, the testimony we heard today was that the defendant did obstruct, delay, and prevent, well, not ultimately prevent, or frankly, the testimony was unclear on whether or not Ms. Kirk was ever able to call 911. But I will say at the very least, he obstructed and delayed an authorized communication from Ms. Kirk's phone right after she told him she was calling police. She attempted to do so. He then took her phone, threw it against the kitchen wall about 10 to 15 feet away, smashing the screen, and then spit in her face immediately after. Your Honor, that's willful and malicious interfering with an electronic communication. Finally, moving to the home invasion first degree charge. Your Honor, there are two theories for which a home invasion first degree can be bound over. The theory that we charged originally was for breaking and entering. I'm pulling from Michigan Criminal and Jury Instruction 25.2A for that charge, Your Honor. First, I have to prove that the defendant broke into a dwelling. Opening a door is enough. Ms. Turk testified that she could not recall if the door was opened for him or if he opened it himself. Your Honor, could not recall is a lot different than trying to act like things didn't happen. What the testimony was clear on is the fact that the first thing she saw after that defendant came over to her house without permission is the dog, and that there was a screen door closed before and another heavy door that wasn't latched. Your Honor, dogs can't open doors, or at least I don't have knowledge of any that can. So circumstantially, we certainly have met the fact that the defendant broke into the dwelling. Someone had to have opened that door, and he was the one that walked in without permission with his dog coming first. So, Your Honor, I would state that we have found that the defendant has broken into the dwelling by a probable cause standard. Whether he entered it or not, I think that's undisputed in this case, Your Honor. We've heard nothing to say that the defendant didn't enter. Third, that when he was entered, present, or leaving in there, he committed assault. Your Honor, not only did he take her phone and smash it against the wall, he spit in her face. He certainly committed an assault. And he did so while Adrian Kirk was lawfully present. That's for criminal jury instruction 25.2A as charged, Your Honor. However, I will also refer the court to 25.2C, home invasion first degree entering without permission. Your Honor, for that theory, we do not have to prove that anyone broke into the house. Simply that someone entered a dwelling without permission. Namely, this defendant entered Ms. Kirk's dwelling without her permission. As for what happened inside, Your Honor, we're not here to address misdemeanors, and I'm not going to speak to them, but they're certainly egregious. An assault was definitely committed inside when someone was lawfully present. For those reasons, I would ask you to bind over whether Your Honor feels more appropriate on 25.2A for breaking and entering or 25.2C for entry without permission. I would ask that the court still binds over on home invasion first degree. Thank you.
Thank you, Your Honor. I asked to start with the counsel today. I'll start with count one, home invasion. Your testimony from Ms. Kirk today. A couple things I want to point out from what Mr. Cairns I think are interesting. He talks about that Ms. Kirk sees the dog go into the home first. What we
So
know,
you see the dog, she sees the dog what first?
going first. What we know is she's not sure, she can't recall how they got open. From her testimony, the screen door was a little bit left open. And I've seen dogs do this. Dogs can push through that if it's a little bit open. So I don't know that it happened here. There's no testimony to support that, but it certainly is a possible theory. But more importantly, does I want to question Ms. Kirk's credibility for everything that happened. Listen to her testimony, not only from my questions, but from Mr. McCarron. She was all over the place and gave a very different rundown and was confusing. I don't necessarily know if I take her to be completely credible. She can give a complete description of what somebody looked like, but when we asked her about how somebody got into the house, she can't recall. I question her credibility, Your Honor. And I'm not certain if you went into this home, if we talk about an assault, there's no evidence that an assault occurred other than what she says. And quite frankly, I don't believe her. You look at count two, Judge. One thing I want to point out is she actually did say something when she was able to get a hold of 911, Your Honor. I don't think there's any evidence to suggest there was a broken phone other than what Ms. Kirk says. And quite frankly, Judge, I don't believe a word that Ms. Kirk says here today. And with regards to count three, Your Honor, I was leaving that to the court. Thank you.
Yes, Your Honor, thank you. I will start with what was obvious and what was clear from Ms. Kirk's testimony is that she was very upset and traumatized by the situation. So these insinuations that someone came into your court, took an oath, and is now lying about every single detail that happened, I think are frankly a bit absurd, Your Honor. Not to mention, I would have objected during it if there was a jury present here, but I didn't feel the need to during the argument. There was no testimony that the screen door was ever open, Your Honor. That was not the testimony. The screen door was closed. Every single time she testified it, every single time she was consistent that the screen door was closed. I went through detail on redirect, described the fact that there was two doors, screen door was always closed, and the other door was basically closed, but just hadn't been touched. Your Honor, somehow this defendant's dog made his way inside, but we're supposed to believe that he somehow didn't open the door or let the dog. Regardless, he entered without permission. So again, Your Honor, whether he broke it or not, frankly, doesn't matter. And referring to it as charged, Mr. Martinez pointed out, we did charge both theories in count, whether it was breaking and entering or entering without permission. Thank you.
It was a date set for preliminary examination on this 5-count felony warrant complaint. The burden is on the prosecution today to establish that they have sufficient probable cause that a crime was committed, and then probable cause sufficient to charge you with these crimes. We only address the felonies today. We do not address any misdemeanors because they don't need to meet that standard at our exam for the misdemeanors. So we're only addressing, for the purposes of today, counts 1, 2, and 3, which are the felonies. And the prosecution only has to present more than mere suspicion that these felonies occurred. They don't have to prove them today. They don't have to prove each one beyond a reasonable doubt. That's a standard reserved for trial, and the trier of fact will make that determination. And so the court will be the sole determiner of credibility today, the credibility of both witnesses, because we had 2, and I'll measure the likelihood of the government's ability to establish guilt at trial, as well as whether or not the evidence as presented today raises reasonable doubt. We have, again, count 1, home invasion, first degree, count 2, interfering with electronic communications, and then count 3, police officer assaulting, resisting, obstructing. We heard testimony today from Officer Alex Slobin from the Lansing Police Department, who testified that on or about August 8th, 2024, he received a dispatch to the area of 508 North Foster Ave. That's located in the city of Lansing, Ingham County, state of Michigan, which makes venue in this court appropriate. He indicated that the nature of the dispatch was a troublesome subject, that when he responded that he made contact with the defendant, or the person he identified in the court as the defendant, Joshua McCauley, he stated that he located this subject sitting on the front porch of the residence of 508 North Foster Ave, that the when questioned, the officer indicated that the defendant did not indicate or give indication that he lived at that address, that there was a dog seated next to him, that the defendant or subject began to hit the dog, that the defendant advised, or the officer advised the defendant to stop, giving him a lawful command, that if he continued to assault or hit the animal, that he would be arrested, that animal control will be contacted. He said that the defendant was then ordered to stand up and get off the porch, that the defendant grabbed his pit bull around the neck and used the animal in a way that would shield him from officers. The officer stated that the defendant failed to comply with their orders, and also orders first to stop hitting the dog, and then also orders to get off the porch, and to stand up and get off the porch. And Officer Slobin testified that he had to pull his taser to advise the subject that he would deploy the taser if there was continued resistance. The second testimony or witness we had was from testimony by alleged victim and or witness Adrian Kirk, who also testified that on or about August 8, 2024, that she made a phone call to the police regarding someone coming into her home. She described that individual by the name of Josh, and that he came into her home uninvited, that she had not met him prior to that night, that she was out that night. They were both out with the dogs, and that she was dog sitting for a friend that she described by the name of Miss Peggy. She stated that the dogs were entangled in the middle of the street, that she asked his name, or that the defendant provided his name as Josh, and told her that he actually lived at 523 North Foster. She said she had never seen him or his dog previously, but that during this time, the dogs were barking and at each other and got tangled up, and that she suggested that they go into the fenced area where the dog she was watching had a new fence. She also suggested that they meet up at a dog park at a future time, since the dogs appear to be friends. She indicated that she went home, that she doesn't know where the defendant went from that point, but that about somewhere between 30 and 45 minutes, I think I heard 45 minutes later on her direct, but I believe on Fox, it was about 30 minutes that the defendant showed up at her house. She testified that her door was locked, but that she did not ensure that the door had been completely closed, causing those locks to latch. That the defendant showed up at her door, he came in and was like, here, providing some water for the dog. She said she can't recall if he opened the door itself or how the door got open. She said he came in and he brought water for the dog. There was some discussion about the dog needing purified water. She stated that she didn't know what was going on, and that she noticed or observed the defendant then begin to punch or strike his dog in the face, that the defendant ordered the victim to also hit the dog. She said that he then wanted to smoke a cigarette. They were out, the defendant was sitting down, began to strike the animal again, and she testified to the defendant urinating all over her back deck. She asked the defendant to leave and retreated to try to contact. She stated the police. She indicated that in response to that, the defendant grabbed her phone from her hand and threw it against the kitchen wall and then spit in her face, to which she responded by then spitting in his face. And the officers arrived not too long after that. Count one, home invasion, first degree, as charged. Again, we'll require the people at trial to prove that the defendant broke into a dwelling. It does not matter whether anything was actually broken. However, some force must have been used. Opening a door, raising a window, and taking off a screen are all examples of enough force to count as a breaking. Entering a dwelling through an already open door or window without using any force does not count as a breaking. Second, that the defendant entered the dwelling. It does not matter whether the defendant got his entire body inside. If the defendant put any part of his body into the dwelling after the breaking, that is enough to count as an entry. Third, as charged, the people would need to prove that the defendant, when the defendant entered, he was present in or was leaving. I'm sorry, that when the defendant broke into the dwelling, he intended to commit, in this particular case, count for assault or assault and battery. Is that how you originally charged it?
No, Your Honor. It was charged originally as while entering, present in, or exiting did commit.
Okay, so under 4B.
Correct.
Okay, that when the defendant entered, was present in, or was leaving the dwelling, he committed the offense, again, count for, which is assault and battery. So the testimony that we have here, again, is that there was a door that was closed. I think a screen door. There's two doors. There was a screen door that was closed, and then there was another door that she described as being heavy, and that she did not think, she believed it was closed, but maybe not closed all the way enough to latch. Based on that testimony, and I agree with the prosecution, there was never testimony that the screen door was left open. And so the defendant allegedly being with the dog, I don't believe would have had the ability to open the screen door, but I don't know what the screen door looks like. However, that dog's being controlled and maneuvered by its owner to this person's house. And those doors are open, and I believe that the testimony supports that there was some breaking, even if it was slight, to enter into the home of Ms. Kirk. And that while she was present, or while the defendant was present, that is, that he committed the offense of an assault and battery, as she testified, that he took her phone from her, threw it against the wall, and spit in her face. So the court is satisfied, based on the testimony, that there is sufficient probable cause as to count one that will be bound over to the circuit court. Count two, interfering with electronic communication, requires that the prosecution prove at trial that the defendant prevented, obstructed, delayed by any means the sending of an authorized communication through a telephone line or electronic medium of communication, internet, a computer program, computer system, or a computer network, any electronic medium of communication. It does not matter whether the communication was actually sent or received. Second, that the defendant did this willfully and maliciously. This means the defendant did the act on purpose and with the intent to prevent, obstruct, or delay the communication. Third, that the incident to be communicated by Ms. Kirk resulted in, well, that one wouldn't apply, so we don't need to deal with that. So we only need the first two elements. Her testimony was that she asked him to leave. She retrieved her phone to make a phone call to the police, that the defendant took her phone, threw it into the kitchen, which she was not stated in the kitchen. She stated, I think, that they were in the living room or the hallway, but that the phone was thrown into the kitchen, and that he spit on her. The court is satisfied that there's sufficient probable cause based on that testimony as to count two that will be bound over. Count three, police officer assault, resisting, obstructing, requires the people to prove at trial that the defendant assaulted, battered, wounded, resisted, obstructed, opposed, or endangered, in this particular case, Officer Alex Slobin, who was an officer of the Lansing Police Department. Second, the defendant knew or had reason to know that Officer Slobin was a police officer performing his duties at the time. And third, that Officer Slobin gave the defendant a lawful command and was making a lawful arrest, or was otherwise performing a lawful act. The officer testified that he ordered the defendant first to stop striking the animal, and that the defendant failed to comply with that order. There was another order or lawful command from Officer Slobin, who stated that he responded due to a dispatch for a troublesome subject, and he ordered the defendant to stand up, or the subject at the time to stand up and to get off the porch, but that the defendant failed to respond or comply, that the defendant got his animal and used it as a shield, and officers had to deploy or remove his taser to bring the defendant into compliance. The court is satisfied, based on the testimony of Officer Slobin, that there's sufficient probable cause as to count three. So counts 1 through 5 will all be bound over, because the misdemeanors will accompany the felonies, to the circuit court for a bind over date of September 11th. That's the date the circuit court's going to get the file from this court. You, Mr. McCauley, do not need to appear in circuit court on that date, okay? Your next court date is going to be a pre-trial at the circuit court. Your attorney will be made aware of that date, okay? Are you on GPS, Devin?
Yes, Your Honor.
Bond was set at 5,000 personal recognizance with GPS survey. It says 2,000 feet exclusion zone, which is interesting to me because it sounds like they live very close to each other. So I don't know how that's worked out.
But he's subsequently left the residence, Your Honor. He is staying somewhere else.
Oh, okay, sounds good. That makes sense. Because I have not received any alerts. Okay,
I don't think he has a desire to go back to the property.
sounds good. Bond,
Different reasons, none of this.
bond will continue as set, including the no contact order. Any additional matters for today's record?
Nothing further from the people. Thank you.
Nothing further from the defense.
You're all set.
And may I post it? Get a copy of the-
Oh, yes. No.
Adrian.
She's good, though.
Okay, sorry for you.
The record in the matter of the people of the city of Lansing versus Carl Johnson, file number 24L2854801. Mr. Johnson? Are you Mr. Johnson?
Yeah, yes, ma'am.
You come to the table. You're standing right there, correct? Today's the date that's set for a arraignment. You walked in on this one. You were supposed to be before, looks like Judge Flores yesterday. No, 2 days ago on the 27th, for opening talks as a passenger. What happened?
They never told me it was on the 27th. They told me it was scheduled for the 13th because the last court I had was on Zoom, and it was on August 3rd, 9:30 a.m. on Zoom. And then they told me the 13th. They never told me the 27th. So I don't know if they changed it.
They sent it in the mail. That part's not your
Okay, where are you talking on my record? Who are you, ma'am?
I'm his mom.
You can have a seat. Okay, I can see this file. You were previously arraigned. And you were given a court date of August 13th. You failed to appear on August 13th. Is that correct?
Yeah, because I had 2 court dates.
Okay, so you failed to appear. The judge issued a bench warrant, but agreed to hold it because you had failed to appear. It looks like on the 13th, that same day, your attorney contacted the court. So they reset your court date as a courtesy, but then you failed to appear. How old are you?
19.
You're 19, so you're old enough to be responsible for your court dates, correct?
Yes,
Okay, and so you knew you had a pending court date?
2 court dates at the same time.
No, I'm talking about you knew you had a pending opening talks. You knew you had a pending case?
Yes.
Okay, when you missed the 13th date, what did you think was gonna happen after that?
I didn't, well, the 13th, they arranged 2 court dates.
I recognize that, not our problem that you have multiple court matters pending. What did you think was gonna happen though when you don't show up to court for a court date?
Well, warrant's gonna be issued.
Correct, but you spoke to your attorney after that, so they said they will get it reset, correct?
They never told me it was getting it reset for the 27th.
But did they tell you they were getting it reset?
Yeah,
Did you find out what the date was?
I found out it was 16th, not the 27th.
Did you appear on the 16th?
They never called me on the 16th.
Who's gonna call you?
I was about to say they never told me about. They never told me about the 27th. That's what I'm trying to tell
Yeah, but you said that they were gonna get it reset for the 16th though, correct?
Yeah.
Did you show up on the 16th?
Yeah, but they must have switched it.
It was never set for the 16th, but did you show up on the 16th?
No, because
Okay.
apparently they changed it.
Every single one.
Ma'am, step outside, please.
Well, she's attacking him.
No, you step outside my court. You don't talk unless you want a contempt of court.
Yeah, I bet you would.
Okay, take her into custody for contempt. It's your responsibility to find out what your court dates are. No one's gonna call you on your court date and say, hey, you
Right.
have court today, okay?
Right, but I don't have a personal phone number to call anyone from.
You're being represented by the public defender's office?
You said, have I?
You're being represented by the public defender's office. Taylor Wicks is who's listed here as your attorney. Have you ever spoken to Taylor Wicks?
Never smoked. Is it a female,
Taylor is a female.
never spoke to her.
You never spoke to an attorney on this matter?
Never spoke to her.
So who did you talk to get your court date reset?
I actually talked to the people for my other court date because I had two, well, what I'm trying to explain, I had two court dates set up.
Off the record. Have a
one
seat, sir.
person-
Have a seat, sir. Did you need me?
I was just coming in.
Oh, okay, thank you.
You said have a seat.
Yeah, I thought they were looking for me, but you're fine. You've
Look.
never spoken to an attorney on this?
Never spoke to a girl named Taylor.
Did you speak to any attorney?
I spoke to an attorney from my other court, but what I'm trying to tell you, what I'm trying to explain is I had two court dates. They shouldn't even never put it for the same time as Zoom.
Where did you have another court date at?
I'm trying to say August 3rd.
I get, you had August 13th. August 13th.
I'm trying to say August 3rd, 9:30 a.m. They said August 13th, not at the same time, but I had another court in person
Where?
at the same time.
Where?
Went downtown.
So you just said they should have never given you two dates at the same time. How, we're not responsible for you having another court date. If you end up having two court dates, it happened, don't talk over me, listen. If you have two court dates, because it happens commonly, we don't know what you got going on in another court. All you do is notify your attorney and they would get it reset. In this particular case, that happened, and so the judge did not issue a bench warrant, but it was reset for the 27th, which was this week.
Right.
And you did not show up, you didn't contact your attorney to find out when your next court date was. My concern is that it's your responsibility to find out. If your attorney didn't call you back to tell you what the date was, it's your responsibility to get in touch with the attorney, and you're being represented by the Office of the Public Defender. You could Google that number.
All right.
It's just your responsibility. So to use it as and put the onus on the attorney is not appropriate. You're the one with the pending charge. It's your responsibility to know your court dates while these matters are pending. Okay, sir?
Yes, ma'am.
Did they give you a notice for your next court date?
No.
Okay, it's gonna now be set for September 10th at 10 o'clock in the morning, okay?
September 10th or 10 o'clock.
10 o'clock in the morning,
September
before
10th.
Judge Flores. He's right over there.
In the other one?
He's in the other courtroom, okay? You're gonna appear for him. We're gonna get you a copy of this paperwork for your next court date. Your attorney I have is Taylor Wicks. I don't know if they've switched attorneys over there. I couldn't speak to that.
I never, yeah, I'm about to say, I never heard of it, like Taylor Wicks. They never told me I had an attorney named Taylor Wicks. They never told me any of that. They just told me my next court date was the 13th.
Correct.
and then-
I see that.
Yeah,
So
that's all they.
well, there's an appearance in the file. Well, so when an attorney represents you, they file an appearance. She is the one who filed the appearance on your behalf. She filed that appearance back on August 8th. So I'm assuming she's still representing you. You need to contact her office, okay? So that you can meet with her.
Is her number gonna be on the paper?
Her number's not gonna be on here. The only thing that's on here is her email, and I'll write that down for you. However, the Ingham County Prosecutor's Office is not too far from here, number one, it's around the corner. Number two, you can always Google their office and call to find out who your attorney is, okay? But I'll give you this email. You should send an email, let them know your contact information and that you want to meet with them prior to your court date. I have a phone number for you, 517-715-7271.
Yeah.
That's accurate. What's your home address?
6705 Hellman Boulevard. You need a lot.
It's 221. Okay, that's a yes, sir.
Yes, you do.
Bond was set at 100 personal cognizance. And you'll remember to keep up with your court dates.
Yeah.
You have a phone?
I got it.
You don't have a phone?
I don't have one that's on.
We're gonna give you, I'm gonna give you this form right here, actually. Can the officer provide him this one, please? Thank you. If you have any questions,
No, ma'am.
you're all set.
Thank you.
You're welcome.